You're listening to the Quint's podcast.
Should we be looking at health conditions or the gravity of offence for prisoners seeking interim bail on health grounds in view of the pandemic? Questions on whether it's right or wrong to keep vulnerable under-trial prisoners in jail have come up with the case of 79-year-old Telugu poet Varavara Rao, who's been imprisoned since the last 2 years over his alleged involvement in the Bhima Koregaon case. He had filed for an interim bail citing his frail health and susceptibility to COVID-19 in March, but a special NIA court rejected the plea. The court rejected it again for the second time in June, and then Rao tested positive for COVID-19 on 16 July. He's said to be severely ill with several neurological issues as well, and has been in and out of hospitals since the end of May. Rao's lawyers then challenged the interim bail plea rejection in the Bombay High Court, but the NIA, which is probing the case, not only opposed it, but they called it a quote-unquote ruse and accused him of taking quote-unquote undue benefit of COVID-19. And Mr. Rao isn't the only political prisoner to be denied bail in this pandemic despite the Supreme Court order on decongesting jails. Anti-CA activists, or for that matter others like Dr. Shoma Sen, Sudha Bhardwaj, Gautam Navlakha, all arrested in the same Bhima Koregaon case, who had also applied for bail in view of COVID-19, too had their bail pleas rejected. Mr. Rao is currently admitted to Nanavati Hospital for neurological and urological treatment, but is it ethical for an under-trial to be refused bail on health grounds in this situation? What did the Supreme Court say about releasing under-trial prisoners to decongest jails, and why are people like Rao made to be an exception? You're listening to The Big Story, the podcast where we dissect the headline-making news for you. And I'm your host, Shorbali. Varavara Rao, who's been booked under the UAPA in the Elgar Parishad case for allegedly inciting violence, had been lodged in Navi Mumbai's Taloja prison, where his health has been deteriorating since the end of May. Rao was taken to JJ Hospital on May 28th after he fell unconscious, but he was discharged on June 1st. And a lot of pleas have been coming from activists, writers, poets, academicians from across the world for his release given his frail health. Since his imprisonment is currently being questioned on moral grounds, let's start with this very question. Is it legally ethical to keep a person like Mr. Rao with vulnerable health conditions in jail in these circumstances? And we have the Quint's legal editor Vakasha Sachdev joining us in this podcast.
To ask whether it's ethical or not, that is the big question here. And I think that's something which runs through all of this, because there is a situation where purely following the rules and purely following the law, you're going to say that yes, someone like Varavara Rao should not be given bail at this point because he's been accused of a very serious offence. He's anyway not entitled to bail because of the UAPA charge, because he's been charged with terrorism offences under UAPA. So, the problem is that we have to at the same time be very careful with trying to make this a purely technical legal argument, and therefore ethics and morality is important, because you are looking at a situation where you are putting people's lives in danger, and they're sort of looking at the bare letter of the law and saying, okay, someone should get bail or not get bail is not particularly correct. And unfortunately, that's something which the courts have not done here.
A lot of details on Rao's health conditions surfaced recently when he was moved to JJ Hospital on July 13 for tests, and his family claimed to have found him lying there on a urine-soaked bed. They not only alleged medical negligence, but also a lack of transparency on Rao's health status. Despite his serious health conditions, his family claimed in a statement that they have not been officially updated about his health. In a joint statement, his wife and daughter wrote, and I'm quoting a few lines, quote, "It is the family's right to get official and transparent updates on his health status, line of treatment, and probable risks, but the concerned prison, police, and health administrations have not come to the family with this information. Not sharing health updates of a person in judicial custody with his family is illegal, unconstitutional, and inhumane. In the absence of official and transparent information, speculation, rumors, and half-truths are being spread, and these cause further anxiety to family and friends." End quote. Rao has been behind bars for 22 months, and his lawyers told the Bombay High Court that given his health conditions, he needs to be taken care by a family member. But the NIA has asked the Bombay High Court to dismiss the bail application, claiming that none of this necessitates him to immediately obtain treatment in a multi-specialty hospital. And I'm reading a line from the NIA affidavit filed by the investigating officer and Superintendent of Police Vikram Khalate. It reads, quote, "The appellant accused Varavara Rao under the garb of the current situation on the account of global pandemic COVID-19 and his old age is trying to take an undue benefit." End quote. But his health conditions aren't exactly a secret. Earlier in June, 15 members of the parliament had written to the Maharashtra government asking it to shift Rao to a hospital because of his ailing health. And even though in the past 6 months the NIA hasn't filed any progress reports or supplementary charge sheets, Rao has been denied bail in the peak of the pandemic, and this despite the Supreme Court order to state governments to release under-trial prisoners to decongest jails. So why are prisoners like Varavara Rao being made an exception to that order? First, let's understand what the order states. On 16 March, a bench of the Supreme Court headed by Chief Justice S.A. Bobde took suo motu cognizance and found that although steps for isolation, quarantine and treatment of possible coronavirus patients had been taken in many of the jails, the problem of overcrowding continued. So a week later, the Supreme Court passed an order directing the setting up of high-powered committees in each state and union territory to determine which classes of prisoner could be released on parole or on interim bail. And this was a much appreciated order, but for a misstep.
Actually, looking at it at this point, the court had taken up this issue suo motu. It wasn't as though someone had filed a PIL. They really seemed to be doing the right thing here. But then you come to the order itself and they sort of allow a very problematic line to slip in. They first give this example and say that, okay, look, when it comes to people who are either accused of or have been convicted of offences where the punishment is more than 7 years, is less than 7 years, then those people should be considered for release. Now, because that's this general idea in Indian criminal law, and you see this across things, that if an offence, the punishment is less than 7 years, then it's not as serious an offence. Without getting into the rights and wrongs of that, the problem is that this example was a little bit tricky because it's immediately saying at the start that when you're considering bail in the context of COVID and the coronavirus, look at the categories of offences. But that's pretty much the wrong approach, because you should be instead looking at people who are going to be most vulnerable to it and making sure they're at the top of the list. But again, if you look at the wording of the order after that as well, it says as aforesaid, when looking at release of prisoners as aforesaid, and it specifically says again, they should have regard for the category of offences. Now this again is a problem, because you've had the Supreme Court is who everyone's going to look to for guidance. They're the ones, their lead is going to be followed here. And here the lead which was being followed was saying, okay, you know what, when we're considering trying to reduce overcrowding of jails, let's focus on the categories of offences. And that's what then happens in the HPCs, in the committees going forward, that they all basically just follow what the Supreme Court said without really looking into the matter with their own thought and approach, except for some states. So for instance, interestingly, Haryana actually specifically said, anyone who's above 65, we have to make sure they get bail, even if, regardless of the offence they've been charged against. But that's just one state out of so many.
What this basically means is that those charged under special laws like the UAPA or the NSA or PSA are automatically excluded from getting bail.
The sentences in these cases are pretty much all above 7 years. And when you're looking at the political prisoners in question here, the tragedy is that they're being charged with the very most serious offences under the UAPA. It's not just saying, okay, look, this is unlawful activity, which has a slightly lower, which is not as serious, but even there the punishment in court high. But at least it's not as serious, and you don't have the embargo on bail there. But these people have all been slapped with sort of proper hardcore terrorism charges or funding terror charges, which all have very, very serious sort of punishment levels in terms of the number of years of imprisonment. So already by making categorization of offences, the categories of offences, the basis for deciding who's going to be released, you've already said that you're not going to grant them bail. Now, the interesting thing, of course, is that even if you were to find a way to say that, if you look, you can get around that, even then the courts haven't really stepped up. So Mihir Desai, senior advocate in Bombay, who's worked on a lot of these UAP cases, he pointed out that at one of its subsequent meetings, the Maharashtra committee, the high-powered committee, actually said that we should give due regard to the age of a person. So if there's someone who's over 60 and has comorbidities and is therefore vulnerable to COVID, then we need to consider bail on a case-to-case basis. Despite that, obviously, because these cases are so politically charged, when there is an attempt to actually ask for bail, as in Varavara Rao's case, the bail is being refused there. And if you read the kind of reasoning given by the NIA or by the authorities to kind of justify it, it's shocking. As we've seen with the Varavara Rao, with the NIA, even now that he's got it, now that they're asking for interim bail now on the basis of his health, they're saying he's trying to take undue benefit. I mean, it's just a horrifically insensitive approach which the investigation agencies are taking. And note that in this case, the evidence against Rao and Sudha Bhardwaj and all is pretty terrible. There's a great article in the Indian Express over the weekend by Colin Gonsalves, where he's pointed out how the evidence against them is actually inadmissible. The moment this case goes to trial, that case is going to fall apart because the evidence is inadmissible. And yet, on the basis of that evidence, they're being kept in jail and denied bail.
Given the seriousness of COVID-19 and the kind of impact it has even after recovery, how can courts step in for undertrials like Rao?
So, in terms of what the courts can do, as we said, there are some states now where the lower courts can actually grant bail, where an NIA court, which is being asked to provide bail to a person above 60, can say, look, even though they're accused of a serious offense, even though the UAP is involved, the HPC has said, the judge can say, I can look at their vulnerability and therefore grant them bail. So that's something which hopefully those courts will be able to do. For other courts, they might find that their hands are a bit tied, but again, there is a certain amount of discretion which lower court judges still have when it comes to bail. But again, as we said, this is something where the lower courts have less authority, so they're mostly bound by what the letter of the law says or by what these high-powered committees have said they can do. So for really trying to take this forward, you're going to have to look at the high courts or the Supreme Court. Now, the high courts, for instance, Bombay High Court is hearing Varavara Rao's petition. Hopefully they will do something here and make sure that he gets some sort of interim bail at this point. Now, obviously, that's not going to stop him from getting COVID, but it would at least maybe ensure that his recovery is not going to be a mess, because we know the kind of damage COVID does to people, to their lungs, to their breathing systems. With Rao, he's having a number of other side conditions, including neurological problems. Now, those kind of things, you can't say that, there has to be, even if he recovers from the coronavirus itself, there needs to be some understanding that he should be given proper medical treatment, and for that he may need to be given interim bail. But the high courts can also do a lot more. I think they're the ones who should start looking into the question of saying, okay, these classifications for how and who should be given interim bail and parole are incorrect, and say that, look, this needs to change. That's something which they have in their power to do. They can take it up on their own on a suo motu basis, or obviously if petitions are filed, they can do that. When cases like Rao's come up, before then they need to make sure they pass good orders. They can also take certain other steps which would help, for instance, mandating a protocol for treatment of people in such situations. Like with Rao, one of the big problems was that leaving aside the question of giving him bail or parole, he should have been given better medical treatment. And this applies whether you're an under trial, whether you're a convict, it should not matter. There's also the question of they need to order more testing as well. There's been very, very minimal testing in these jails. The Loja jail where Rao was based had already seen cases of the coronavirus, and yet there was no testing being done, even when it was like of someone who was right next to a person with extreme vulnerability. Now remember that Rao was in the same prison cell as Vernon Gonsalves, who was having to look after him, who was also above 60 and also at risk thanks to the coronavirus. So, these are the things which the high courts have to look at, that maybe build better protocols for treatment, for testing, which they can do. The Supreme Court would hopefully, one can only hope, look into this again, given they had taken this up suo motu once. But then again, I mean, they're going to have to acknowledge that they got it wrong with the kind of classification they suggested.
If you like listening to this episode, please subscribe to the Big Story playlist for episodic updates. We're live on Apple, Google Podcast, Spotify, JioSaavn, and most of the other popular podcast streaming platforms. For other podcasts, please log on to the Quint website and check out the podcast section. For any feedback, shoot an email to podcasts@thequint.com.
Thanks for listening. Log on to the Quint's website and check out our other podcasts.